Mrs. Wendy indicates there's something you want to take up outside the presence of the jury. Is that right?
Well, Judge, I filed a motion yesterday. I'm going to receive a copy of it.
This one? Third supplemental motions in limine.
Correct, Your Honor.
Okay.
I don't know if the court wants to take that up now or just move on with Veal and then we can take it up.
Is Chief Ramsdale going to testify later today?
No, Your Honor.
Okay, well,
My understanding
The
is,
only,
go ahead.
the only witness that is going to testify later today, the subject of that motion, is Russ Hicks. But the state would suggest that we finish up Dr. Veal, and then we can address any issues that have with respect to Mr. Hicks.
okay, that's fine with me. So are we otherwise ready for the jury?
Yes, sir. Yes, sir.
All right, Mrs. Woody, let's have the jury.
Go.
Good morning, Your Honor.
Good morning, Doctor.
No, I think that should do it. Okay. Anybody else? Sorry. Thank you.
Okay, Mr. Conrad, you can continue when you're ready.
Thank you, Robert. I'll try and keep this brief, especially since we're running out of paper here. Good morning, doctor.
Good morning.
So I think where we left off last time is we were talking about Mr. Ellis's pulse and the facts that you relied upon in support of your opinions today. And I had asked you whether at the time that you drafted your report and gave your defense interview with us, it was your belief that Mr. Ellis did not have a pulse when EMS arrived, right?
That was my initial understanding, yes.
Okay, that's what you stated in your interview with us when we specifically asked you. Is it your understanding that Mr. Ellis had a pulse upon EMS arrival, and you said no?
Yes, based on the paramedic's description.
Okay. And, well, the paramedic description means Lieutenant Wilson.
Yes,
Okay. And Lieutenant Wilson said in his interview with Washington State Patrol, which you reviewed that as well, right?
correct.
That Mr. Ellis had a pulse as well.
He said he was bradycardic, and given the strip that I had, that suggested he was not feeling every pulse generated by the electrical impulse, because some of them were, 110 beats a minute electrically, and yet he described it as bradycardia. Therefore, I believed that he must have not been perfusing every pulse.
Okay. And what do you mean not perfusing every pulse? Well, let me ask you this. You mean, if my understanding is correctly, when you're talking about perfusion, you're talking about the heart's ability to circulate blood, right?
Yes,
Okay. And so you were saying that you believe that because he noted him as bradycardic within interviews, right?
yes, sir.
That you believe that he was not feeling every one of the QRS, those points that we've seen on
Yes,
that he's not feeling every one of those pulses.
yes, sir.
Okay. And that led you to believe that he didn't have a pulse.
It led me to believe that he was not perfusing every beat
Okay. And
that
actually,
you could see on the strip.
Sorry? The end of your.
That you could see on the strip.
Okay. And you reviewed Lieutenant Wilson's testimony as
I
well,
did.
right? Like
I
the
did.
testimony from where he's sitting, or you're sitting today.
Yes, sir.
Okay, so you were provided with transcripts of that testimony.
I was.
And he talks about perfusion as well within that testimony, does he not?
I don't recall the specifics, but
He did.
I don't recall the specifics of his discussion of perfusion.
Okay. So we've covered pulse. I want to move on to this idea of bradycardia as well, which you've mentioned now a couple of times. And so I want to show you the actual transcript. It's Exhibit 2578 regarding what Lieutenant Wilson stated about Mr. Ellis' pulse. Your Honor, may I approach?
Yes.
Thank you. 2578.
Thank you.
And could you flip to page 45?
I'm on page 45.
Not yet. Lines 5 through 12. And the question on line 5 was, and it was also bradycardic, right? I read that correctly?
Yes, you did.
And he says, answer, as it was irregular, right?
Right.
The question then is, and tell us how irregular. What was the variation of how irregular it was? That's the question.
I see that, yes.
And he says, answer, it would speed up and go slower. And as you could see from the prior exhibit, the rate is sporadic. At times it's very slow, at times it's within normal or higher than that. Did I read that correctly?
Yes, you did.
Okay. Do you remember during your defense interview, we also asked you about tachycardia? Remember that?
I don't specifically recall, but if you'll,
Sure, I can help you.
thank
So
you.
First, let's talk about bradycardia, tachycardia, and kind of a normal rhythm.
Sure.
So bradycardia, would you agree with me, is a rhythm that's typically below 60 beats per minute?
Agreed.
Okay.
Yes, sir.
And then what's considered normal heart rate is anywhere from 60 to 100.
Yes.
And then anything above 100 would be considered a high heart rate and called tachycardia, right?
Yes.
Okay. And then I'll show you what's been marked as State's Exhibit 518. Is that okay, Judge?
Yes.
Thank you. 518. I'm going to ask that you flip to page 39 of that.
Page 39. I am on page 39.
Keep beating the document. Lines 13 through 15, if you could review those, and then I want to ask you a couple questions about it.
Right.
Okay. So we asked you about your opinions regarding any tachyrhythms that Mr. Ellis had during your defense interview. Remember that?
I do remember that.
Okay.
Before I saw the testimony of Lieutenant Wilson, and before I saw the full strips from the life pack, the combination of those two things did change opinions.
Okay. And when we asked you about whether there was a tachyrhythm, you said that any tachyrhythm that was present would be as a result of any epinephrine that the paramedics gave him. That's what you stated, right?
Based on having a 6-second strip that was part of the paramedics report before the defense provided the state with the code stat data.
And the strip that you're talking about, that's from Exhibit 24, is that right? Sorry.
If Exhibit
That's
24
not-
is
okay,
Lieutenant
let me show you-
Wilson's report, yes.
No, yeah, this is the
That is,
pre-hospital care
I
report.
recognize that right away.
Okay.
What are you guys at a time?
Yeah,
You're both
I
talking at the
didn't
same
get any
time?
of that.
That's
don't
my
do
fault.
that.
That's my fault, Jeff. So Exhibit 24, that's the pre-hospital care report,
Yes, sir.
correct? Okay, and so you were looking at the initial strip that you're talking about within that pre-hospital care report?
Yes, sir.
Okay, and what, the time period of that initial strip, can you refresh your recollection as to what it is? And when you're done, can you look up, because I want to ask you a question about it.
Well, what I can tell you is that there are more pages here than I had, meaning the strip that was on his original report that I was provided was this first strip right here. And then there are pages of other strips that I had not seen.
Okay.
Yeah.
I just want to ask you about the timing of that first strip that you were relying upon. It's at 11:37:32, right?
Yes, sir.
Okay, so 37:32, and could you go to page 2 of the report.
Page 2 of the report, yes, sir.
And the first time that's indicated that Mr. Ellis receives any epinephrine is at 11:42:19, correct?
That's correct.
Okay. So that initial rhythm strip that you were relying upon actually came before any epinephrine?
That is correct.
Okay. So the next thing I want to ask you about is, we talked a little bit about yesterday, our client, Officer Rankine, as well as his partner, Officer Ford, saying that they had heard Mr. Ellis say, "I can't breathe." Remember that?
Yes.
Okay. And that both of them had indicated during their interviews it was weird to them in that situation, because one of the things that was weird was that he was saying it in such a calm voice. Remember that?
They did both say that.
Okay. And then, do you remember in your interview with us, we asked you about that, whether it was, if it was true that they both heard it in a calm voice, and you indicated that if it was in a calm voice, it wouldn't have really been of a huge concern to you at that point, right?
If it was truly in a calm voice, yes. And that was one time.
And you know, obviously, that, well, you testified that, strike that, I'll just move on. So the last thing I want to ask you about, for now, I guess, is the medical records that you relied upon. The medical records that you relied upon included a large amount of Mr. Ellis's health records, correct?
Yes, sir.
Okay, and it's important to look at those records to see kind of a picture of the overall health of an individual. Would you agree with me on that?
Yes.
Right? Where they've come from, what they've been affected by in the past, right?
Yes.
Okay. And one of the things that was indicated in those medical records was that Mr. Ellis had a history of asthma, right?
That was mentioned, yes.
It even mentioned in those records evidence of, or records indicating hypoxia, history of hypoxia. Remember that?
I can't say I recall that. I don't remember seeing
Okay.
that. Yes.
And there's a number of records that indicate that he's had previous breathing issues as well, right? Chest pain or breathing issues.
He's had chest pains which were nonspecific, yes.
Okay. Meaning they don't know why at that point.
We still don't.
Okay. And do you know when the last time that Mr. Ellis was having breathing problems was?
I know that one time he was, I believe, speaking to a counselor and said he was short of breath, and they encouraged him to go seek attention for that. I don't know much further about that.
Do you remember when that was?
The prior year, I think.
In 2019?
Could have been earlier, but I don't know.
Earlier meaning
Earlier
20
than,
or 20?
no, earlier than 19. I don't know.
Okay. I think that's all I have for you, Doctor. Thank you.
Thank you, sir.
Redirect.
Thank you. Dr. Veal, good morning.
Good morning.
I want to follow up with regard to the last line of questioning regarding the medical records that you reviewed for Mr. Ellis. You were asked about his asthma and any evidence of chest pains. Do you recall that?
I do recall.
All right. What did you observe about, and you did review his medical records, is that correct?
I did, yes.
What did you observe about Mr. Ellis's medical records?
Well, there was a great deal
Let me rest again. What did you observe about his medical records? Pretty big question. Can you hone it down just a little bit?
Yeah. What did you see in the medical records with respect to the asthma and any breathing issues?
There was a mention of asthma. I don't recall any documentation of his ever having a chest exam with wheezing or pulmonary function tests. And I know that most of the time that in those medical records, he behaved as though he had normal pulmonary function.
You were also asked about whether you saw anything in the medical records regarding chest pains. What did you see in the medical records with respect to Mr. Ellis's heart?
He did have between,
I'm gonna object, it's beyond the scope, and I think it's violate prior motion.
I'm
sorry.
sorry, it's what?
Beyond the scope and violate prior motions.
No,
Over.
I'm open to going on.
Overruled. You may answer.
he did have a period of 18 to 24 months of idiopathic pericarditis where the lining around the heart, because the heart sits in a cavity that has a lining around it and a lining that coats it. And that typically is a pretty empty space with a little bit of oily fluid in there so your heart beats freely. He had inflammation of those membranes for, again, 18 months or so, which is why we have such a good record of his prior cardiac status. Not that long, 2 years-ish before this event.
But what is the significance of that, Doctor?
He had normal biventricular, both sides of the heart. He had normal function and an ejection fraction. And let me digress and say, ejection fraction is when your heart fills up with blood, it's got that much. When it empties, it's got that much. And the amount that goes out with each heartbeat is a percentage. It's called an ejection fraction. Normal is about 60%. His was 60 to 65% about 2 years before.
So it's normal.
Normal.
And did you also review whether Mr. Ellis received echocardiograms in 2016 and 2017?
This
That,
goes way beyond the scope. I asked him whether he had chest pain.
Yeah.
Non-specific chest pain.
I don't know.
Also opened the
Did,
door regarding chest pains
Well-
and medical records that Dr. reviewed.
but I'm wondering about an examination that was 4 years or 3 years before all this. Did that play a role in your opinions? Any echocardiograms from 2016 or 15?
no.
So it's
The
irrelevant.
most recent one,
Which was?
I believe it was in 2000, end of 17, early 18,
You can ask him about that.
in that window.
And what did you see in that echocardiogram?
That is the echocardiogram I was just describing.
Okay. And what did it show?
Normal biventricular function, normal valves, no cardiac abnormality demonstrated at that time.
You indicated there was Mr. Ellis suffered from pericarditis, is that correct?
For a period of time, there was no evidence of that on autopsy.
What is the significance of, and was it last reported in 2017?
Object, bleeding. Beyond the scope.
Overruled. When was the last report?
I believe it was 2017.
Is there any significance to the fact that it was last reported in 2017?
Given that his last cardiac imaging was normal and he had no further episodes and had no evidence of pericardial disease at postmortem, I don't, please ask again.
Is there any significance to whether pericarditis was last reported in 2017?
Only in that it allowed us to have an image of his heart after it returned to normal.
You were asked on cross-examination by Mr. Kurtzer whether Officer Burbank was on Mr. Ellis's back or on his buttocks. Do you recall that line of questioning?
I do.
And you indicated that it was suggested by Mr. Kurtzer that Officer Burbank.
Form of the question.
It was suggested by Mr. Kurtzer that Mr. Officer Burbank was on Mr. Ellis's buttocks. Do you recall that?
I do recall that.
Have you had a chance to review Officer Rankin's testimony, or actually his statements?
Yes.
And do you now recall what Officer Burbank's position was in relation to Mr. Ellis?
Yeah, my review confirmed the reason I was confused about the buttocks issue yesterday was it stated that he was seated on his back. That was per Officer Rankine.
That Officer Burbank was seated on his back?
Yes.
Did Officer Rankin describe him straddling him like riding a horse?
He did specifically, yes.
Interesting.
You indicated that it does matter whether Officer Burbank was on Mr. Ellis's buttocks or on his back. Do you recall that?
I do recall that.
Why does that matter?
Because as we discussed yesterday with the ribs and the need for the chest to rise and fall, if one has pressure on one's pelvis, that's not going to inhibit the thorax that much. But if one has pressure in the center of the back, it would inhibit it to some extent.
And Doctor, we described hypoxia as a level of oxygen that's not sufficient to allow normal cellular respiration. Is that correct?
Correct.
Is this a cumulative process?
It would be cumulative over time, yes.
And is Officer Burbank's positioning, is that relevant to this process?
It certainly could have contributed to subsequent hypoxia.
And then we know that Officer Rankin then switched positions with Officer Burbank and got on top of Mr. Ellis. Is that also relevant to this process? Is there any relevance to then the officer's positioning on top of Mr. Ellis?
Yes.
And does Officer Burbank and Officer Rankin's position relevant to that process?
Yes, it is.
During cross-examination by Mr. Conrad, you testified that progressive bradycardia is strong evidence of hypoxia. Do you recall that?
I do.
Can you explain to the jury why that is?
There is quite a list of medications which can slow the heart in that manner. None of those were detected in the toxicologic exam. Apart from that, and apart from coronary disease affecting his conduction system, and we know he didn't have any coronary disease of note at the time of his postmortem, absent those things, the drugs or the specific low blood flow to the conduction system, global cardiac ischemia or low oxygen provided to the heart muscle, and likely acidosis would be the most likely cause of progressive bradycardia.
You were, Doctor, you were asked by Mr. Conrad regarding tachyrhythms that you observed on the COSTAT data.
Yes,
Do you
sir.
recall that? And you have had a chance to review the data.
I have.
There's a suggestion that there's evidence of tachycardia prior to the administration of epinephrine.
Yes, sir.
Did you see any evidence of that?
Well, once again, when I was first provided the records, I was given the one strip that was on the original report by Lieutenant Wilson. And in that one strip, the first half was clearly very bradycardic, and the second half looked, it was irregular, but the beats were closer together, 100, 110 beats per minute, and yet he described him as bradycardic. Thus, I assumed that he wasn't perfusing those beats. That opinion changed when I saw Lieutenant Wilson's testimony, because once I saw that and the code stat data, which played out all the rhythms, it became very clear that he did have a pulse that was very irregular and then progressively bradycardic over several minutes.
Dr. Veal, you were asked on cross-examination regarding the amount of weight applied on Mr. Ellis's back, the duration of the pressure that was applied to his back. Your opinion on whether Mr. Ellis suffered hypoxia, does it depend on knowing the precise weight and time?
It does not. We know what happened in terms of the progressive bradycardia that we've already discussed, and that would not have occurred had there not been sufficient time and weight to prevent him from adequately getting oxygen in and CO2 out.
On cross-examination, doctor, you were asked about accounts of Mr. Ellis struggling, moving in restraints. Do you recall that?
I do.
And you had earlier described or testified regarding air hunger. Do you recall that?
I do.
And if a person was experiencing air hunger or struggling to breathe, what would you expect to see from this person?
You know, you got to scope the cross. He's asked and answered correct, was never brought up the cross.
I'm sorry, the last part?
It was asked and answered incorrect, it was never brought up the cross.
The doctor was cross-examined at valid accounts of Mr. Ellis struggling in restraints.
Not about your,
This was brought up already on direct, so I'll sustain the objection.
Your Honor, I have no further questions. Thank you, doctor.
Thank you.
Mr. Purcell?
doctor, excuse me 1 second, I gotta grab a exhibit here.
Yes, sir.
Doctor, excuse me for 1 second.
Yes, sir.
Doctor, good morning.
Good morning.
Just kind of clarify the situation regarding positions of both, actually Officer Burbank and Collins and then Officer Rankine.
Yes, sir.
Okay. And I'm going to hand you what's marked as Exhibit 50A, which is Officer Burbank's transcript, and then 65A, which is Officer Rankine's transcript. Yes, sir.
Thank you.
Now, it is correct, is it not, that we have the events involving Mr. Ellis, Officer Collins, and Officer Burbank, correct?
Yes.
When it starts out, it's Officer Collins, Officer Burbank trying to arrest
Yes.
Mr. Ellis. They are struggling with Mr. Ellis.
Yes.
Correct? He is trying to avoid, to stop them from trying to arrest him, based on your review of the materials.
Yes.
He's resisting their advances to get his hands behind his back.
Yes.
Okay. And if you would turn, please, to page I'm sorry, just exhibit 50A, is that Burbank?
That's Burbank.
Yeah. If you could turn, please, to page 28 of Officer Burbank's record, line 20.
Yes.
And starting at line 20, page 28, I'm sorry, page 28, line 20 through line 2, page 29. You take a look at those pages.
Line
Yeah,
2.
page 28 and line 20. Do you have those?
I do.
Sir, thank you. And it states that, and this is Officer Burbank stating, based
I
on,
have to object, this is Mr. Person testifying by reading Officer Burbank's statement.
What are you trying to accomplish here, Mr. Bircher?
well, I'm just, I'm rebutting what exactly the doctor stated that Officer Burbank said.
You're trying to point out there's evidence contrary to what Officer Rankine said?
Judge, I'll ask it a different way.
Okay.
Doctor, with respect to what Officer Burbank is stating, where in this, does he state that he was sitting on Mr. Ellis?
No, he does not. This highlights one problem with all of the interviews.
Fair enough. But
Very inconsistent.
my question was specifically, does he state that he is sitting on or straddling Mr. Ellis?
He does not state what Officer Rankin says he observed.
Well, you're gonna get there. We're gonna get there. Does he state that he's sitting on Mr. Ellis?
He doesn't.
Now, in fact, what does he state that he and Officer Collins are doing at this point in time? Starting on line 20.
He says that they were basically just kind of laying on top of him.
Both he and Officer Collins are laying on top of him.
That's what he says.
I understand.
Yeah.
They're trying to pin him to the ground to keep him from flailing and kicking around, is what Officer Burbank states, correct?
That is how the transcript reads.
Well, this is a transcript of Officer Burbank's statement that's taken 3 days after the event.
How is this argumentative?
That's not a question.
Is this a statement that Officer Burbank gave 3 days after the event?
Yes, sir, it is.
All right. And so he is telling the investigator what he did that late evening, correct?
He is telling them his statement.
Okay.
Yes.
And he also talks about being exhausted during this process,
Yes, he does.
right? And they're just trying to pin him to the ground at this point. based on the statement.
based on his statement.
Okay, and so Officer Collins and Officer Burbank are they're trying to get him under control at this point in time.
That is what is described.
And they're trying to cuff him, to arrest him.
He was already cuffed.
Been asked and answered.
Overruled, you may answer.
I'm sorry?
He was already cuffed when they were laying on him.
Yeah, just trying to stop him from moving, correct?
Yes.
Okay. And then if you can turn to Exhibit 65. And take a look at page 10, line 23, through page 11, line 5.
Yes.
And in this,
This is 65A.
it is
65A.
65A.
Yes, Judge.
And this is Officer Rankine's statement regarding the events that occurred that evening, correct?
Yes, sir.
And in that reference, Officer Rankine states that he says that, I remember that Officer Burbank was still on top of him, like seated on top of him, correct?
Yes, he does.
All right? And he states that Officer Burbank asked him for help,
Yes,
okay?
he offered to assist.
He did. He says, all right, I got you, correct? Page 11.
Yes,
And then he says he transitioned up to Mr. Ellis's upper torso, correct?
yes, he does.
Once we had pretty much secured his legs, correct?
Yes, that's what he says.
Even though he was still kicking and bucking pretty violently, correct?
Yes,
So this encounter, at this point in time, we have Officer Collins, Officer Burbank, Officer Ford, and Officer Rankine trying to stop Mr. Ellis's motion, his fight.
Your Honor, this line of questioning has been already asked and answered.
Well, during your redirect examination, you got the doctor to say something along the lines of that the precise weight and time of pressure on Mr. Ellis's back doesn't matter. Mr. Bircher's trying to point out that it does, I think.
Correct.
So I'll let him ask his questions.
So Doctor, we know there are at least 4 police officers, actually there's 5 police officers, including Sergeant Lynn, trying to restrain Mr. Ellis at the same time, correct?
that is correct.
And Mr. Ellis only has handcuffs behind his back at this point in time.
No, at this point in time, his hands and his feet were secured.
Well, his hands are secured, he's not hobbled yet.
Well, there may be a disagreement here about what time you're talking about in your question. You were talking about, when you went to the transcript of Officer Rankine, you talked about Rankine transitioning to Ellis's upper torso once the legs were controlled, right?
That's correct.
So that suggests the legs are bound.
Well, let me ask, thank you, Judge. I don't think that's accurate, but let me flesh that out. We know, Doctor, that Officers Collins and Rankine are together and they are trying to handcuff Mr. Ellis, correct?
He was handcuffed at the time that he says, Officer Rankine says, line 9 on page 11 of State Exhibit 65A. I remember right before I transitioned to his upper torso, comma, me and Officer Ford checked to make sure his cuffs, comma, like his hands, comma, were completely cuffed up.
Correct, his handcuffs.
Yes,
He wasn't hobbled.
Mr. Burtzer,
Okay.
here again, you said he wasn't handcuffed at that time,
Let me rephrase.
so.
Doctor, this transcript from both Officers Rankin and Officer Burbank indicate that Mr. Ellis was handcuffed at the time of this initial encounter, correct?
At the point I just read, yes.
Correct. He is not, Mr. Ellis has not been hobbled yet, correct?
I don't think he's been hobbled. Officer Rankin describes his legs having been secured.
Correct. And we know from other transcripts that you do that Officer Lim, who arrived after Officers Rankin and Ford, grabbed Mr. Ellis's legs, correct?
I recall that, yes.
And so we have 5 officers that are trying to stop Mr. Ellis from flailing around before hobbles are applied. Correct?
Yes.
All right. Now, in the transcripts indicate that Officer Rankin switched positions with Officer Burbank, who was exhausted and just basically rolled off of Mr. Ellis, correct?
I know that they did exchange positions.
Well, he says he rolled off of it, correct?
I don't recall the specific language, but if you want to give me a page in Exhibit 50A, I'm happy to look at it.
You know, rolled off is probably my words.
Could be.
But there was a transition between Officers Rankin and Burbank, correct?
There was a transition.
All right. Officer Burbank was no longer in contact with Mr. Ellis.
I don't know that.
Oh, it doesn't appear based on the transcripts that he was in contact with Mr. Ellis.
I can't know that.
Okay. You indicated before that if a person is handcuffed and hobbled, that in and of itself will not create hypoxia, correct?
I did indicate that.
And that's been through the studies throughout the research that you conducted,
Yes, sir.
right? It's when there is a specific amount of weight that is placed consistently that hypoxia can occur.
Consistency or intermittently with cumulative effect. Yes.
Okay, all right. And we know that there was a period of time where Mr. Ellis was being restrained long after, after Burbank and Collins were no longer in contact with him. He was placed into the recovery position and he re-engaged his activity, correct?
Yes.
All right. And so but we don't know based on the records you reviewed how much time passed.
No, we do not.
But we do know that Officer Burbank and Collins were with Mr. Ellis for 2 or 3 minutes. Officer Rankin and Ford appeared, correct?
Yes.
And then 10 minutes later, the medical personnel appeared.
Yes, sir.
Okay.
8 minutes and 31 seconds.
8 minutes and 31 seconds, according to Mr. Frick, correct?
Yes.
No, excuse me 1 second. Judge, excuse me 1 second. Doctor, if you could turn please to page 30 of Exhibit 50A. Is 50, is that Burbank?
50A is Officer Burbank.
Oh, great, thanks. If you turn to page 30, please.
I am there, sir.
And if you could review for yourself lines 1 through 15.
Lines 1 through 15.
Yes, sir. Actually, 1 through 20. Take 1 through 20.
1 through 20?
Yes, please.
Yes, sir, I've completed that.
Okay, does that refresh your recollection of the sequence of events that occurred after Sergeant Lim arrived?
It does refresh my memory as to what Officer Burbank reported.
Okay, and he reported that he remembers telling Sergeant Lim that he's in cuffs, meaning Mr. Ellis is in cuffs, correct?
Yes, sir.
And then he states, I just kind of rolled off the suspect to kind of catch my breath,
He does state that.
all right? And then somebody asked him about hobbles to restrain Mr. Ellis's feet,
Yes, sir.
correct? And then he went to his patrol vehicle and obtained hobbles.
Yes, sir.
Ah,
That's what he says.
That's what he states in his
Yes, sir.
transcript. And also, I believe you said that at the time that Mr. Ellis, at this point in time, after he's been handcuffed, and then he's hobbled, he's still able to recover from a potential hypoxic event at that point in
He was able to have at least partial recovery.
time. And he was starting to recover.
He
after-
regained consciousness.
Okay.
Yeah.
Well, did
Or,
he lose-
or I should say, showed that he was able to be conscious.
Right,
Yes.
he didn't lose consciousness at any point in time.
I don't believe I know that, in that he had stopped struggling momentarily, which is why they placed him in the recovery position, and then he began to recover, and so I cannot say whether he was conscious or unconscious at any time prior to that.
Well, when he's struggling, pursuant to when Casey Jones was there watching him bang his head into the ground, he was not unconscious at that point.
He was not at that point.
And that is minutes after Officers Burbank and Collins are no longer active with Mr. Ellis, correct?
I believe so.
All right, and so during that period of time, he is conscious, he is thrashing around, he is struggling vitally against being hobbled and being restrained. Correct?
Yes.
Dr. Dayton, that's all the questions.
Thank you, sir.
Mr. Oster.
Just a couple questions, please, Judge. Good morning, doctor, how are you?
Good morning.
It sounded like you reviewed Officer Rankin's transcripts last night to clarify the position of Officer Burbank during that exchange. Is that accurate?
I did.
Who asked you to do that?
Oh, I did, because I was questioned yesterday as to was he sitting on buttocks or was he sitting on back, and I remembered back, but I hadn't read it again until last night.
Okay.
Yes.
And so you clarified, or at least took some effort to clarify where Officer Burbank was during that initial exchange prior to hobbles. Is that right?
Yes, sir.
You didn't need to clarify where Officer Collins was, did you?
That was not the issue that I was questioned about, so no.
Because every piece of information that you have places Officer Collins on Mr. Ellis's legs until hobbles are applied, right?
After the initial struggle during which they were
Sure.
different, yes, I believe that is correct.
And let's be clear. Officer Collins was on his back at his, being Mr. Ellis's, at certain times until the cuffs were actually applied, right?
Yes, sir.
Once the cuffs are applied, every piece of information that you have, video or statement from anybody that's there, has Officer Collins trying to control Mr. Ellis's legs only, right?
The ones that I recall, yes.
All right. And yesterday, Mr. Conrad asked you about other officers who also assisted in restraining Mr. Ellis. Do you remember that line of questioning?
I do.
He mentioned Officer Madden, right?
Yes,
And you qualified her contact as only being on the legs of Mr. Ellis as well, right?
yes,
That's because in order to be responsible for the hypoxic component of this, there must have been weight applied to the torso post-restraint, right?
that is what I believe.
And so you differentiated Officer Madden from any of the other ones that mentioned by Mr. Conrad because your information had her applying only weight on the legs, right?
Yes,
Same as Officer Collins, right?
that is what she described.
And Officer Komarovsky, same thing, right?
Yes,
Sergeant Lim, same thing, right?
yes,
Officer Ford, same thing, right?
I believe so. Yes,
And you mentioned that just a minute ago on redirect by Mr. Liu that there were inconsistencies between the police statements. Is that right? Did I understand that correctly?
yes. Some who were there described never seeing anyone on his back.
Sure.
No one, and they were standing right there.
Understood.
They also described not hearing him say anything that you could hear from the doorbell camera across the street.
Okay.
So very inconsistent.
Okay. But what was consistent, Doctor, was that Officer Matthew Collins applied weight post-handcuffing only to Mr. Ellis's legs, right?
That is my understanding.
And that cannot cause the downward pressure necessary to cause hypoxia, can it?
I agree with that.
Okay, that's all I have.
Mr. Conrad.
Is it okay if I stay here?
Wherever you're comfortable.
Can you speak up?
Yes, ma'am. So, Doctor, on redirect with Mr. Liu, you discussed this 2017 echo of Mr. Ellis, right?
Yes, sir.
Okay, and so that's roughly 3 years prior to this incident.
While I know that 20 minus 17 is 3, I think I think it was closer to 2 years apart, this being in March of 2020. And I think that echo was in the latter half of 17. It was between 2 and 3 years.
Okay, and you know from those records as well that between those years, Mr. Ellis is continuing to use methamphetamine.
I do know that.
Both oral injection as well as IV injection, correct?
Not clear on that at all. I think his use of anything intravenously was supposed to be remote. I don't recall.
Okay. He continued to use other drugs as well, right?
Cannabis, maybe. I don't recall which other drugs.
Okay. Would you agree with me, not the healthiest of lifestyles, right?
Oh, definitely not a healthy lifestyle.
And then obviously we have, fast forward to 2020, we have what his autopsy results are as well, right?
We do.
Okay. I don't have any further questions. Thank you.
Dr. Veal, you were just asked about Mr. Ellis's methamphetamine use.
Yes,
Conrad.
I was.
First of all, did you make a determination whether Mr. Ellis, whether the meth in his system affected him?
I'm
Or
gonna object beyond the
you opened the
scope.
door?
Sustained.
What physiological impacts on the EKG strip, doctor, would you expect to see if someone is suffering from methamphetamine toxicity?
I'm gonna object beyond the scope.
Sustained.
Got it. Mr. Conrad, open the door.
He asked him about whether or not there is continued methamphetamine use and use of other drugs would have had an impact in his general health compared to the electrocardiogram that was taken in 2.5 or so years before.
Thank you, doctor. I have no further questions.
Thank you.
Mr. Bertram?
Nothing more, Judge, thank you.
Mr. Elsner?
Nothing, Judge, thank you.
Nothing more, Judge, thank you.
Okay, Doctor, thank you very much. You're excused.
Thank you, sir.
Take care. Mr. Liu or Ms. Eakes, next witness?
Your Honor, the next witness is Russ Hicks.
We have a discussion about him first, right?
Correct.
Okay, ladies and gentlemen, please excuse us while we have this discussion. Please do not discuss the case. Okay. So there's this issue of, well, Mr. Usher, you're standing now too, so you got some other issue?
I don't want to sit down, Judge.
You don't want to,
I don't want to be sitting anymore.
oh, all right, feel free to relax, as long as you're not promoting anxiety in me. Okay, so there was an issue, the motion in limine with respect to Mr. Hick about whether or not handcuffing, hobbling, hog-tying, prone restraint, or spit hoods are dangerous. And about, I'm not sure what all else, I'm not sure there was an issue as to training as to him. I don't know if it says it in the motion itself, but in the body of the, yeah, I guess it does. About evidence about police trainings that weren't actually provided to some or all of these defendants. So, I guess, Mr. Conrad, this was your motion. I don't know if there's anything else you want to add other than what's in your written materials that I got yesterday afternoon.
Does the court have any specific questions? I
No,
think
not really. As I understand it, Mr. Hick is a former Criminal Justice Training Commission instructor.
Correct, Your Honor. With respect to Mr. Hicks, first of all, the state does not intend to ask about whether or not any of those things are dangerous as it pertains to the first motion.
Okay. So I should grant that as to at least Mr.
Yes,
Hick.
that's fine.
What about, since we got him here, what about former Chief Ramsdell and former Chief Aki?
Same, we're not intending to ask whether or not those are dangerous practices.
All right. Now, the defendants have any comment about it? No?
Well, I think in terms of dangerousness, right, that's not the only adjective or I would use to describe it, but, I mean.
You're
we're
trying to
not-
broaden your motion now that you've made it?
No, well, my motion was based on the fact that, I guess the line of questioning that, at least that we witnessed. And so it goes to their opinion about issues related to prone restraint or handcuffing, what their opinions on those matters are. It doesn't matter, what their opinions are, first of all, they don't have a foundation for it or a basis for it. And it doesn't matter what their opinions on it are. So that's what it goes, that was the essence of the motion, Judge.
Well, at the moment of this motion, they're not opposing it, so I guess
Okay.
I'm granting it. So.
As long as
that'll
we're
be
on the same
granted.
page.
So as to trainings,
Yeah, Your Honor, with respect to training, Mr. Hicks was both a longtime trainer at the Criminal Justice Training Center. He actually trained all three defendants, and then he was the assistant director of CJTC. His testimony, he's familiar because of his roles there as a trainer, and then also, more importantly, he was required to oversee all the scenarios that are given to officers in order to test, whether or not what they were taught is, whether or not they're carrying it out in the scenario training. So he has personal knowledge of all the training that was given at the CJTC, and specifically that was given to these three officers. So that's the basis for his knowledge with respect to what he's going to testify about.
well, I think in Mr. Conrad's motion, he says at page 4, line 9, Mr. Hicks shared PowerPoint slides with the state that were created after Officer Rankine completed the Basic Law Enforcement Academy, which the state apparently plans to use as evidence. I take it that would have been also after Burbank and Collins.
Yeah, and we don't intend to introduce any PowerPoints that occurred after training.
So what are you going to ask him about exactly at this point? I mean,
We're gonna ask him about principles that were taught at the CJTC with respect to a variety of topics.
right.
Including the training that officers receive with respect to the appropriate uses of force, the training they receive with respect to dealing with people in crisis, the training they receive with respect to the legal basis for contacts with individuals, the training they receive with respect to the prone positioning.
Legal contact with people?
Correct.
We're going to talk about Terry stops? I mean, what do we,
Yes, just generally about the training that they receive with respect to that and the contacts.
is he going to criticize anything that happened here?
No, he doesn't have any knowledge about this case. He's simply a fact witness as it relates to the training generally. So he's not being asked opinions with respect to this particular case or what was carried out, just what the training was given. And he'll describe all of kind of BLEA and what is taught generally to the officers and, the certification process that they have to go through.
Is anybody going to say that there was something deficient about the way in which the force was used here?
Yes, Jack Ryan is.
What's he going to tell
The
us?
state's police practices expert is going to walk.
He's the use of force expert? Is that what
He's
you
the
said?
use of force expert.
And what's he going to tell us?
He's gonna tell us a variety of things. I can defer to Ms. Nicolavo if the court wants with respect to all of the.
Sure.
But he's provided a report with respect to his criticisms, or his statements about the uses of force and whether or not the various uses of force were justified in this case. Specifically including the strikes, the contacts, whether or not procedure was followed, what officers were trained on in terms of the initial contact with Mr. Ellis, as well as the specific uses of each one of the uses of force that needs to be justified to be reasonable and necessary, and only that amount which is necessary. And then the ceasing of all force once the resistance has been overcome. Those are among the opinions that he has.
So if he's going to say all that, why do we need to hear from Mr. Hick?
Well, because And one of the issues that the defense has raised, and I believe that the court said, is that you're not gonna allow testimony about about training that these officers didn't actually receive. So this is about training that these officers actually received on these principles.
Mr. Conrad?
I mean, we spoke with Mr. Hicks as well. I don't know if you noticed in our report that we had previously consulted with him. He's an expert on use of force stuff in another case, and approached him on this case as well to see what he would, whether he would be a part of it, or just discuss issues with him. In fact, the state asked him about our communications with him as well, which I find problematic.
So you talked to Mr. Hick about being a witness for the defense?
In terms of expert, we had used him as an expert in another case.
Yeah.
And what he told us was that he wasn't the instructor for our client for anything related to defensive tactics, where they would have taught you cuffing procedures, restraint procedures. That would have been Richard Lee. And so when we talked to him about the fact that the state had named him as a witness later on, he was shocked by that, actually. He said, I don't know why I would be, because I wasn't the one that taught him that stuff. So he talks in generalities about what they've taught in the CJTC during periods of time, but he also acknowledges that he's not the one who taught it, that the curriculum was always changing, which he says in his report, and that the specific instructor, who we know is Rich Lee, and the state was intending on calling him today, at least that's what they give us notice of as well, that Rich Lee is the one who actually taught this to our client.
To Officer Rankine?
Correct.
Not to Burbank and Collins, maybe?
I don't know. I didn't focus on that aspect of it. This has been a big undertaking for our firm, because we got all this huge amounts of training materials from the state originally, as the court knows. Well, then what we did is, I said, we need to figure out what the specific materials were and instructors were for our client, especially given the court's ruling. So we sent out a subpoena to the CJTC, and we've been working with Derek Zabel from the CJTC to try and figure out what those materials are and who the instructors were. Then we met with Richard Lee, who was the defensive tactics instructor who actually taught our client on certain issues. So again, Russ Hicks is not the right guy in this circumstance. If the state's saying he is, then I think we need an offer of proof as to what he's intending on testifying to. Because the other issue is, when I'm reading his report, he talks about the fact that, they would have been taught not to place their full body weight on a suspect who's handcuffed and hogtied, but they don't teach hogtying at the CJTC. They don't do any training on it. They don't even discuss that with them, from my understanding. So, him stating that now, I think, after the fact, when he's not the actual instructor, he doesn't know that. He doesn't know what the materials were that were actually produced to them. And so I think him testifying in this case, at least on the issues related to Officer Rankine, what he was trained on, I think is inappropriate, because he's just not. It's Richard Lee. It's not.
Are you calling Mr. Lee too?
We may call Mr. Lee. That's what we were intended to do, depending on, if there's gonna be overlap and cumulative, then no, then we're not gonna need to call Mr. Lee. But let me address first of all the issue of the claim that he was a consultant. My understanding is that defense reached out to Mr. Hicks and asked him to get involved, and he indicated that he would not be a consulting expert because he had disciplined Mr. Rankine, Officer Rankine, when he was at the academy. And as the court knows, there were issues with Defendant Rankine at the academy, and he knows that that's not something to be covered, and that the court has excluded it. But he never consulted on the case, and he never became a consulting expert. They simply reached out. But he is the fact witness that knows about the training at the Criminal Justice Training Center. While he didn't teach every single course, as I just said he doesn't need to teach every single course, because one, he's been there for 14 years. Two, he runs the scenarios that follow up from the lectures, so he is aware of what is being taught. So these are very, important principles in terms of what the training was.
Well, if you're going to call Lee anyway, why are you calling Officer Hicks?
Because Officer, Mr. Hicks,
Mr.
who's
Hicks.
no longer there, is important because he has the overall picture. All defense is talking about with Hicks, with Mr. Lee, is related to defensive tactics. But there are broader issues than defensive tactics in this case, including patrol procedures, including the other training that they receive with respect to first aid. Those are all issues that can be covered by Mr. Hicks. And if Mr. Hicks, he also is familiar with all of the training as it relates to defensive tactics. So if he covers those subjects as well, then we don't need to call Mr. Lee. But he's the more encompassing person who's been there for 14 years and specifically was involved in the training of these 3 officers. And that's an important fact in this case, what their training was and whether or not they followed training. Particularly when the defense got up an opening and said they followed their training 100%. Well, it's important to understand what they were trained and for the jury to understand whether or not they did in fact follow their training.
Well, in what way was the training, what way did they not follow the training?
In what way did they not follow the training?
Yeah.
Well, I'll give you just one example. They did not follow the training by leaving somebody in the prone position. That is a transitory position, that they are taught that as soon as they get somebody cuffed, that they're supposed to move them out of the prone position.
I mean, what it sounds like, Judge, is that they're using him as he does plaintiffs and defense expert work on use of force, that they're going to use him as a use of force expert. He himself, I believe, will tell, if he's going to be honest, will tell this court that he is not the one who trained our client, that Richard Lee is the training officer of those materials. I have the schedule, which puts him on the schedule at time frames. He's not on there for that. He knows that it's Richard Lee. He told me himself that it was Richard Lee.
Mr. Lee might have trained him with respect to defensive tactics, as I've said, but we're talking about overall training at the CJTC, and he's not being used as an expert witness. I don't intend to ask him any questions about the facts of this case. I'm asking him about what occurred with Mr. Ellis. I intend to ask him only about the training that was given at the CJTC on these principles. And that's a fundamental thing that the court has said we need to tie the training to these individual defendants.
Well, I said if you're gonna go into a training issue, is what I said.
And which we've indicated we are, and the defense has been aware fully that
Well,
Mr.
and
Ryan.
in that, it's always nice to have the context. The context was, I think, that you were talking about a use of force expert from other jurisdictions who had never been here, like Louisville, and I Washington DC or something, I can't remember.
Well, right, the defense raised issues with respect to the training, and so that's why this is about the training that these officers actually received in Washington at the CJTC, and Mr. Hicks was involved.
But what's the, I guess the thing about this is, well, let me ask you this, is Mr. Hicks gonna say there was anything improper about stopping Mr. Ellis at all?
Mr. Hicks isn't going to talk about the Ellis
Right.
situation.
Well, I asked you about Terry stops, and he said something like, yeah, we're gonna talk about that.
He's gonna talk about the fact that officers are trained with respect to how to have contact with individuals.
Yeah,
Both a social contact as well as a Terry stop, as well as probable cause, just the general training on that subject.
I mean, Judge, he's going to say things like, officers are taught not to leave someone in a prone position. They're taught to never put people in a prone position, to ever place weight on their back. I mean, those are just opinions on things without actually saying Officer Rankine would have been taught to, but that's just not true, because he's not the guy who taught it. And he says, even in our conversations with him, he said that it's completely variable. It changes over time of who's doing the trainings and what the materials are. And that's why we undertook the process of going to the CJTC, doing a subpoena, working with Derek Zabel from the CJTC, and figuring out that Russ Hicks and Bob Bragg are the 2 guys that covered these subjects. And they want to call Russ Hicks instead because he's going to provide opinions on this case.
Your Honor,
you said Richard Lee and Bob Bragg covered it, not Mr. Hicks.
Yeah, you
Sorry,
missed
I
it.
misspoke. Richard Lee and Bob Bragg.
Yeah.
Sorry.
Your Honor, this is, I mean, the defense wants us to, look, this is a witness who can cover the whole gambit of what the training was, because of his role there, and because of
Yeah,
his
but see,
knowledge
I don't
of
want to
this
teach these
knowledge.
jurors how to become police officers.
No, and we're not going to. I mean, my directive is probably gonna be 45 minutes, 30 to 45 minutes, and these are about some key principles, as the court has just heard.
Well, I'm trying to figure out right now what it is in their training that they didn't follow.
They didn't follow prone positioning.
Well, wait, that's debatable, but but they've conceded that we would not leave him in the prone position if he wasn't struggling, so we rolled him over.
And even, but what Mr. Hicks will say is that what the teaching is that if you don't leave people in the prone position after they have been handcuffed, they should be sat up, seated, placed into a patrol car, or at least at the minimum, rolled onto their side throughout the time. So again, you don't leave anybody in the prone position.
So
and
at what point should Mr. Ellis have been put on a patrol car?
Right away, I would say. And I think that that's what our expert would have said, what our expert would say.
Apparently what Mr. Lee or Mr. Hicks is gonna say also. But he's not the one who
I'm only talking about what the officers are trained about, Your Honor. Again, these are disputed facts. I mean, we can't just accept what the defense wants the facts to be. It's what these officers are trained on and whether or not they're
Well,
following their training.
but these witnesses, as you have pointed out, are not going to provide us any facts about what happened here.
They're going to provide us facts about what the training was. And that's important for them for the jury to understand, not just what Jack Ryan says, but what these actual officers were trained on. And they were trained on these specific principles that we're gonna discuss with Mr. Hicks.
So,
That's important.
so what,
What their knowledge is.
so what you're saying is that they should have put Mr. Ellis in a patrol car the moment he was handcuffed.
Your Honor, I'm saying that.
Is that what you're
will
saying?
say-
No, answer my question. Is that what you're saying?
Well, Your Honor, I don't think it's my position to say that that's exactly how it should be done. What he will
Well, I need to have some idea of the theory of this as to why it matters, because it seems to me that he was still kicking and what have you, and then they decided to put hobbles on him, and it wasn't it was less than a minute when they decided he needed medical aid, in which case you wouldn't put him in a squad car, would you?
Yes, you would. What the training will be, what the training was, is that after somebody is restrained, you need to move them into a position in which they're able to breathe. You get them out of the prone position, not just because of the breathing issue, but also because of the anxiety associated with being face down on the ground. At that point, there are a number of options, and those depend on the circumstances. But certainly having other officers there, he could have been rolled to his side, he could have been sat up, and other officers can assist in holding him to restraint. So the idea that, well, he's flailing and therefore the only option is to pin him to the ground is not what the training is. And that's the important issue.
Well, you have to figure out whether or not it was doable to put somebody in a squad car who's trying to kick you.
Correct. That's one of the variables. But it is, again, this is about the training that they receive about how do they.
I
deal with
understand that you're telling me that it's about the training, and I'm telling you, I don't want to hear about how to become a police officer. What I need to hear about is something that suggests that they went outside their training in some manner that somehow would indicate that there was a risk to Mr. Ellis's life, that they would have been aware of that,
Correct.
that they didn't heed that.
Correct, and this is fundamental to what Jack Ryan is gonna say on those topics as well. I mean, that is part of.
Then why just have Mr. Ryan?
Well, I mean, we just have Mr. Ryan, the court has already said that we have to be able to show that these officers were actually trained on these principles, which is what Russ Hicks is able to provide.
There's been no argument about this aspect.
Well, there is an argument about it. They've already challenged whether.
Well, then I'll tell you, put it this way, you can keep him in reserve, and we'll see what the examination is on the other witness. And if it challenges, you don't know anything about the guy's training, so you don't know whether that's right or wrong, then you could bring Hicks in to explain that. Why do we have to hear him now?
Because again, I think that it is an important part for this jury to hear from somebody who actually did the training, is familiar with the training.
But he didn't actually do the training,
He did.
not for these officers.
Yes, he did. That's what I'm telling the court. He was both trainer as well as ran all of the scenarios for each one of these defendants.
He trained Officer Rankine.
He did, and he was his task officer. He was his, and he knows all of the training that Officer Rankin received.
So you're talking about the training that Officer Rankine would have received with respect to control of the suspect after he's been handcuffed and putting him
All
on the
of those
stomach.
topics, Your Honor.
Right.
All of those topics. Again, because he has to run the scenarios, so.
I still think I'm right. We don't need to hear from Officer Hicks until somebody's pointed out that there's a problem with all of that. Because otherwise, we're just wasting time.
Well, Your Honor, I mean, this is, I don't know, I mean, this is not wasting time. I mean, this is a critically important issue.
You've heard my ruling. I'm not going to reconsider it.
Okay, well, we don't have any other witnesses right now.
What's your next witness?
Well, if the court's not gonna allow anybody from CJTC to testify, we don't have anybody at all today. And we have to figure out what we're doing tomorrow, because that's what we intended to put on. That's what we've given the defense notice of.
Who are you going to put on tomorrow?
That's what I need to figure out, if the court, because this is what we were intending. I know James Bible's gonna testify tomorrow, but other than that, I'm still sorting it out.
What's Mr. Bible going to testify about?
He's gonna address the issues that the defense has been raising with respect to his contacts with the witnesses and the suggestion that he did something with respect to their calls. There are a number of questions that have been asked repeatedly. I can provide the court with all the transcript references to what Mr. Bible did and the suggestion that Mr. Bible somehow the phones disappeared or had some issue after Mr. Bible had contact with the witnesses. And I think that as a result of that, the Mr. Bible's testimony with respect to his contacts with the witnesses and the suggestion that he shared any information, if he had any information about the case, with those witnesses is important.
This is why the case may go to January. I don't see the need for Mr. Bible, to be honest with you.
Your Honor, I mean, again, you're letting the defense raise issues and create boogeymen and say.
Look,
suggest that they have-
those exhibits have all been admitted.
Well, it doesn't
The
matter
only thing it goes to really, the business about Mr. Bible, was the idea that the witnesses in question, like Ms. McDowell, for instance, potentially Mr. Cowden, were sympathetic to the position of the Ellis family, and therefore aligned themselves with Mr. Bible, and it's that way of showing, well, they've got a bias and there's a credibility issue. What is Mr. Bible going to tell us about that?
Mr. Bible's going to explain how he came into contact with those individuals, what, if any, information.
They've explained all that.
with them.
I mean, nobody's denying that they had that communication.
Yeah, and it's the nature of the communication, right? It's being suggested by the defense that there was something improper there, and that the reason that Ayanna White has a phone is because she never had contact with James Bible, but the other witnesses had contact with James Bible, and therefore we don't have any of the underlying phone evidence.
The evidence is in, I don't know.
Well, it's not just the fact, counsel.
Well, because Mr. Bible can't say what happened to the phones.
Well,
he didn't-
didn't say that
he-
he didn't have any discussion.
He never had the phones either, right?
Correct, well, has that been established?
Yeah,
I mean,
they testified. I sent the video over the internet. Both of them said that. In fact, Mr. Cowden said, I had to retrieve it from a friend of mine who I'd sent it to, and then I forwarded it. So he never said he gave the phone to Mr. Bible, and neither did Ms. McDowell. Right?
Well, yes, and that's why the court allowed him to question the witnesses to suggest that somehow there had been something improper in their contact with Mr. Bible. And the fact of the matter was, there isn't, and there wasn't anything improper about the contact with Mr. Bible. And that's what the state seeks to put him on, to address.
You can ask him more than two questions?
Not very many, right.
All right, well, who else besides Mr. Bible?
I don't know yet, Your Honor, because of.
I mean, if you're simply going to say,
I can't call these folks. This was the lineup, is with respect to this evidence. And I mean, frankly, we're gonna need to adjust if the court's not gonna do that and see what witnesses we can get available.
well, it's got to be something that's in dispute in this case. I mean,
Well, it is in dispute. It's in dispute. I mean, the defense stood up an opening and said, they followed all of their training.
Right,
They didn't
right.
have any training
Officer Collins has
whatsoever.
not given an opening statement.
Well, that's true.
He says he didn't.
Well, that may be, but nevertheless, opening statements were made. But
Correct.
the only training I'm hearing so far is that they should have rolled somebody over on their side. And I guess you're also saying you should have put him in a squad car? But is they're gonna say under the circumstances where the person is kicking like this, they could put him in the squad car?
I'm sorry.
Judge, can I make one observation?
Yeah, Mr. Conrad.
So
This also goes to the, I'm sorry, I didn't mean to interrupt.
It's okay.
I was listening to too many people.
I mean, there are a number of witnesses that have very relevant information that were there firsthand at scene. We're past October. We haven't heard from any of the other officers.
Well, if your criticism is the order in which the state's calling their case, I'm not gonna hear that.
I mean,
It's their case, they can call it any way they want. If they wanna bring a witness in that's not gonna advance the ball, then I reserve my right to say, that's not gonna do us any good.
fair enough, fair enough. I guess one of my concerns is like, you know, the state makes a comment the other day that they're not sure if they're gonna call
Dr. Clark?
Dr. Clark, right? I mean, that's a big confrontation issue I would see, but then,
Well, that's what you keep telling me.
but on top of that, well,
I'm not sure I agree, but.
I can brief it out for you, Judge. I can do that. So the issue with that also though is that we've been concerned about that, so we've been out and trying to serve a subpoena on Dr. Clark, and then we get an email from the state saying, our understanding is that you're trying to serve Dr. Clark with a subpoena, knock it off, essentially. And then we hear that they're not going to call him. I mean, I guess I'm getting sidetracked, but there are plenty of witnesses that the state can call that could advance the ball.
Your Honor, I would just say that what counsel just eliminated was that we indicated that, that Dr. Clark, said that he would stay under the state subpoena and he would be available to any party that wants to call him in the case. He was just upset that he has a process server who keeps coming to his house and banging on his door at all hours of the day.
All he's gotta do is answer the door and take the subpoena.
Well, I'm just telling you, he feels very threatened by by the way that the process server was gonna go, and so, but we've already indicated to
Well,
counsel.
why wouldn't he open the door?
Your Honor,
Yes, Ms. Sokolovo, maybe you can shed some light on this.
I spoke with Dr. Clark, and he has a registered agent for service, and that person has not been served. And he's had multiple days in which someone has tried to serve him.
He has a registered agent for what?
For service, for his company, you're required to serve.
For his company.
You're required to serve as registered agent.
If you're suing the party, which is the company.
I'm just letting the court.
No, I
know.
understand that, but people don't have, individuals do not have a registered agents to accept service of
The
process.
privacy of his home was a concern to him. He doesn't open the door for strangers, period. And he has a camera, so he's able to see that I don't know this person. And so he asked us to contact defense, and we contacted them to let them know he's going to be available for the duration of the trial.
I don't know, I think he should just deal with the problem. That would make it simpler for everybody. Well,
I respect the court has a difference of opinion on that. I understand what you're
he's evading service of process, Ms. Sokolovo. If somebody else, any other witness was doing this, and you were on the prosecutor's side, hold on, and the defense witness was doing this, you'd say issue a warrant for his arrest.
He let me know, and I wouldn't say issue a warrant for his arrest. I come to the court to ask for assistance and guidance. He let me know, and as soon as he let me know, I let defense counsel know right after I got off the phone.
That doesn't solve the problem, to be honest with you. Will I have a legal basis to have him arrested if he doesn't show up? When he hasn't been subpoenaed by the
Your Honor,
defense?
he's under the state subpoena for the entire trial.
Right, unless you release him.
I'm not releasing him. That's what I confirmed with him, and he will make himself available for the entire trial.
Even though you're not gonna call him.
I haven't said that. I'm not, the state has not made one position or the other. I'm just saying on the subpoena.
But you're the ones that created this ambiguity by mentioning that you may not call him.
This occurred before, I believe, that comment was ever made.
Correct.
This happened over the weekend.
Well, I mean, the evasion of service of process.
I'm not answering the door and, yeah.
Anyway,
Your Honor, with respect to, and I know the court said you're not gonna change your mind, but, I can either make my record or wait with respect to other things that, Mr. Hicks would testify about. So I don't know if the court wants to hear any of that, or if you just want me to submit something in writing, which I'm happy to do as well. I don't wanna try the court's patience, but, I wanna make sure that I'm giving the court full information with respect to what we were told, Mr. Hicks for.
well, I have made my ruling. So, who are you gonna be calling next?
Karen, can we have take the morning break and let us
Sure.
talk about, we don't have anybody currently planned for the rest of today, given the two individuals who are from the CJTC.
Sure. Well, if you're gonna call Dr. Clark and he's at hand, why don't you just call him this afternoon?
I don't know that he's available, he had some medical issues, so.
Okay, we'll take our break. Let the jury know. witnesses.
Well, Your Honor, here's, we wanted to seek some clarification. As I understood what the court said, we understood the court to be saying that we may call Jack Ryan, who can testify to what training was received by these officers and his opinions with respect to whether or not they followed the training. And that after, that potentially depending on the cross, that the court may or may not allow us to call Mr. Hicks and others. So I guess what we're trying to clarify is that there was also an issue with respect to, and we intended to have witnesses out here from North Carolina as to the training materials as it relates to Officer Burbank, and we intended to call Chief Ramsdale as a witness. And I'm seeking clarification of, based on what I heard the court say, it sounded like you're not gonna permit those training aspects either. And if that's true, then we just need to make adjustments to our case based on that. The defense was objecting to the North Carolina records, and therefore we were having to bring out custodians to show what the training was of Officer Burbank. And I don't know if the court's now gonna require that in order for Jack Ryan to be able to testify about those records or not. So that's my first question, I guess.
I think we have to start from the premise that the state is arguing that there was some violation of police training protocol. And that violation was non-trivial,
Correct,
that had something to do with the death of Mr. Ellis.
correct.
I'm not sure what that is that the state's claiming now, that they should have placed Mr. Ellis in a squad car at some point in time.
As I indicated, Your Honor, it's a variety of things. That they were supposed to not continue to use force once he was under control, that they were trained on that. So once he's in handcuffs and hobbled, you have to cease the use of force.
So the use of force being weight on his body
Correct,
and rolling him over on his side.
correct. And that is, putting weight on somebody is considered a use of force. That there were uses of force in terms of using the taser that weren't consistent with police training.
So you're saying, wait a minute, hold on. Not consistent with police training, what do you mean by that?
That in order to use the taser, you have to justify each use of force based on the activities or the actions of the individual. And that there
Right.
was nothing here that justified particularly the third use of the taser.
So the first two were fine?
No, I wouldn't necessarily say that, but with respect to.
Was the first one fine? Was the use of a taser at all fine?
I think that our police practices expert will say, based on what's observed in terms of Mr. Ellis's activity, no, it was not.
I mean, having looked at the video,
Correct, he's been through the video.
that's what Mr. Ryan will say?
Correct, that's my understanding.
And how does the use of the taser play into the death of Mr. Ellis? It didn't kill him.
It's not about whether or not it killed him, it's also as it goes to the uses of force generally based on the conduct.
Right.
The officers engaged in with respect to whether or not the detention and the uses of force by Officer Collins and Burbank were reasonable and appropriate.
Yeah, but this is not a civil litigation for damages. So how does it tell us anything about the charge of murder in the second degree, for instance?
Your Honor, it goes to whether or not one of the issues on the murder in the second degree is whether or not he was lawfully detained, whether or not he was assaulted, an assault 2 or an assault 3. And if there's no justification for the use of the taser, then that's it, potentially falls into both an assault 2 and an assault 3. I would also note that another.
As excessive force.
Yes, that it wasn't justified and therefore it's an assault under assault 2 or assault 3. If there's no justification for the use of that. Just like.
It's probably not an assault 2 or 3, it might be an assault 4.
I think that under the assault 3 prong, it would qualify.
How?
I have to look at the exact language, but, and.
wasn't negligently or recklessly inflicted, it was intentionally inflicted, right?
Correct. It was negligently and recklessly and intentionally inflicted, if there's no justification.
So it's negligence, huh? Okay.
Another aspect of it is, that, part of the training was that they were, required, to inquire if somebody was injured and to respond, and they were trained on how to respond to if someone indicates that they can't breathe in terms of medical. So these are all additional things that go to their training.
Well, sure, but when did they ask for medical in that context?
Well, actually, none of these officers asked for medical, and the only request for medical was in response to dispatch.
Yeah. Even assuming that's right, that happened when Sergeant Lem was present, right? Sergeant Lem
Sergeant
off,
Lem was on the radio when dispatch asked whether or not they wanted medical to arrive.
and he
The
said,
training-
yes.
Okay, said you can send them to check them out. And the
Right.
testimony from the paramedic was that they understood this to be just an eval subject to an arrest.
And this was how long after Mr. Ellis had actually been subdued? 12 seconds, according to Mr. Osser.
But again, Your Honor, I think that we're talking about, this is the defense version.
No, we're looking at a timeline that your client, that your experts established.
Yes, and the training is that one thing that's important.
No, don't change subjects on me. Is it true or not true that it was 12 seconds after Mr. Ellis was finally subdued that medical was asked for?
I don't recall the exact time.
Is it any, Sue Peters' report, which is also one of your use of force experts? So were you suggesting some other period of time?
No, I'm not suggesting that.
Well, then let's get back to the training then. So is your use of force expert going to say that 12 seconds was too long?
He's going to say that they're required to inquire about somebody's medical condition.
Right, but that doesn't tell me anything unless it's in the context of this case.
Understood. And that they, in the context of this case,
Yeah.
they should have relayed to fire and to the other officers at the scene that Mr. Ellis had indicated over a 2-minute period of time that he couldn't breathe. And that is contrary to their training, that they didn't advise fire or anybody else, because that obviously impacts the amount of time that it takes for them to respond. Similarly.
So
they decided to
so who should have done that and when?
all of these defendants who took him into custody and were having contact with him should have done that.
Well, what about the fact that Sergeant Lem was on the scene and he was in fact talking directly to dispatch about
And
it?
their training is that just because there is some superior officer on scene does not alleviate them of their duty of caretaking function. And that's another thing that they're trained on, about their caretaking function.
Yes, but they would have potentially heard Sergeant Lem asking for medical to arrive. So wouldn't that take care of it?
No, it doesn't.
Why not?
They have independent obligations when they take somebody into custody.
Well, wait, what does that mean, an independent obligation? They were supposed to also contact dispatch and say the same thing Sergeant Lem
They
just
needed
said.
to ensure that the information was given to fire and dispatch as to what they were dealing with at the scene with respect to Mr. Ellis. Specifically,
So the criminal act here was not providing enough information to dispatch and to report to medical?
it's the totality of all of the facts and their behavior.
I'm
It's
trying to
the totality
figure,
of all of it. Mr. Ellis is at the scene, hogtied repeatedly, and we know from the audio and the video saying that he can't breathe. He says it over a 2-minute period of time. That information
Yeah.
was never relayed to anybody in a position who could have helped them on a medical from the EMS standpoint. That's just one of the facts.
well, one of the facts, it seems to me, is that that was relayed or not, it was Sergeant Lem whose mic was open about the medical. And when that mic was open, you were able to hear Mr. Ellis say, "I can't breathe." Right?
Correct.
So dispatch heard that.
I don't know if dispatch heard that, but fire didn't hear it.
No. I'm I'm trying to tie these things into what these officers did or didn't do.
That's what we're doing, Your Honor.
Well, you're really tying it into what the entire, when Mr. Liu made his opening statement in this case, he broadly referred to them, they, the actions they did. And it wasn't specific as to these defendants. Even the they and the them was sort of encompassing of the Tacoma Police Department as a whole. And maybe the Tacoma Police Department as a whole failed in some ways here. We're not judging that here. But if the Tacoma Police Department failed in some way, that doesn't make these folks liable for murder. That's why the training deficiencies, if any, have got to be tied into what the charges are here and the behavior of the defendants. So you're claiming the taser, for instance, was something that contributed to the death of Mr. Ellis.
As the medical experts have already said, the taser may have, would have increased, the use of the taser would have increased his need for oxygen.
Right.
And I would
No,
point out that-
one other point about that, if I could ask. That's certainly true, they did say that. Some of them kind of discounted how important that would be, but in the whole picture of things. Doesn't there have to be more than just a doctor would know this? Doesn't the defendants have to know this?
And you won't let us put on that they actually understand that they have training, which includes that after somebody deploys a taser against them, that they need to call for medical aid. I mean, that's one of the things that they're also trained on. And so I think that our evidence is specifically related to these
But-
defendants.
Well, the other problem, of course, is that medical aid was in fact called.
And what was called but was not given the critical information that they needed to have with respect to the severity of Mr. Ellis's condition, including what their training is that if they have excited delirium, which they claim is what they believed at the time of the scene, that they're to treat it like a medical emergency and they need to notify fire about the fact that they believe that it's excited delirium.
All right, so again, but I guess I'm clear now that this is, that the criminal act here comes down to their failure to properly notify medical authorities.
Part of the criminal acts, Your Honor.
Okay.
Correct. So with respect to North Carolina and to Chief Ramsdell, I was trying to understand if the court's saying we can't put on any training until after Jack Ryan testifies about what specific training these.
Yeah, I don't need to hear about their whole life story unless I have some reason to think it's an issue in the case. And things like notifying medical authorities when somebody's injured, I think is kind of a matter of course and sort of commonly understood by almost anybody. Here, the argument's going to be evidently that medical was notified. So there's going to be an argument about what the significance of that was, I guess. And there may be some difference about the significance of Sergeant Lem's appearance on the scene in terms of who was supposed to do what. They may have had an independent duty here for purposes of training. Do they have an independent duty for purposes of criminal liability?
But we believe so, under a recklessness standard. I mean, if you know of your training and you disregard and don't follow your training,
Right.
that's part of criminal negligence and criminal recklessness.
Could be.
That's the state's position. We think the evidence shows that.
Well, there's evidence. There's other evidence too. It's undisputed. Anyway, so your question is, yes, and if Mr. Ryan talks about some of these things that are sort of non-controversial, then I don't expect we'll ever need to hear from Mr. Hicks. If it turns out that there's some question about whether or not the training differs in the state of Washington or that these officers received, then you can go there.
And with respect to North Carolina then and Chief Ramsdell,
I don't know why you would need them. It's the same issue, right?
well, that's what I'm just trying to make sure, because obviously that affects our. And I would note, I mean, and maybe the defense won't go there now that the court has clarified this, but in the defense interview of Jack Ryan, this is where they attacked him, that he didn't know what these officers were trained on in the state of Washington. If they choose not to do that, then obviously may shorten up those witnesses. But at this point, we have reason to believe that they are challenging that, and and particularly in light of Defendant Rankin's opening statement. And that's why we want to put on evidence of what the training is.
Well, I don't think they're backing off of that, but, with respect to Sue Peters, do you need her too? What's she gonna say that's different?
I'm not sure we're gonna call her, but depending on what Jack Ryan covers, is what the court's concerns about.
Okay, so what's your, so now that you are clarified about where we're coming from, who are you gonna call next?
We're gonna call, Dr. Clark tomorrow.
Anyone else tomorrow?
Can't imagine that Dr. Clark is, gonna be done tomorrow, but,
You're probably right about that.
not currently.
Okay.
Because we were gonna call James Bible, but the court's already now said that you can't call James Bible, so.
I didn't say you can't call Mr. Bible, I'm just saying, what has he
Well, I
got to
thought
do?
you did say I couldn't call Mr.
No, I said, what are you gonna do? I mean, you're gonna ask him 2 questions about, I got these videos and I never altered them? Beyond that? What is there to ask him? You can't say, you can't vouch for the credibility of Ms. McDowell.
Don't intend to ask him to vouch.
Right, so,
Only about the contacts and what, if any, information he shared with them, and about his communications, if any, about the phones.
right, but he can't restate what they told him. All he can say is, I got information and I reported it to authorities and that kind of stuff. But it's a very short witness, I would think.
Correct.
And so there may be a thing or two there that you can have him talk about. But again, these are items that are largely not in dispute.
I would have thought they were not in dispute, but until the questions were being asked. So
Well, there was some
we put on
question,
that.
there's question, as I said, about the bias of McDowell and Cowden, for instance, because they didn't turn to police authorities, they turned to Mr. Bible, which shows a certain sympathy for Mr. Ellis. And under the circumstances, we might all have felt the same way. I'm not criticizing them for that, but it's why the defense asked about it.
Well, I don't,
No one suggested, there was some suggestion about what they did with the phones. There was no suggestion that Mr. Bible did anything inappropriate that I've heard.
well, I believe that the transcript will reflect that they did. They suggested in cross-examination or asked directly of Ms. White that she was the only one who still had her phone because she didn't have any contact with Mr. Bible, versus the other witnesses who met with Mr. Bible and then suddenly their phone evidence isn't available. And I have all the
Yeah.
citations.
No, that's all true, but I didn't disagree with you before, but the problem there was neither McDowell nor Cowden ever said that they ever provided the phone to Mr. Bible. So what's Mr. Bible gonna say? They didn't give me the phone?
And
Which no one's arguing about,
And he didn't tell them to destroy the phones,
okay?
or to destroy the information on the phones.
Yeah, the one phone was just locked up, apparently I guess the theory is that it seemed to be multiple repeated failed efforts to get into the phone using a passcode, which didn't work. And so then the phone locked up on its own as a result of its own software. And then with respect to Mr. Cowden's phone, it was just gone, right? And as I say, so he retrieved the video from somebody else he had sent it to, which is the reason why, which was explained to the jury, the reason why it did not have any audio, because the file he sent did not contain audio file. Although it may originally have had an audio file. So to that extent, the video was altered from the original. But it still got admitted. All right, well, Dr. Clark, tomorrow, you guys, let me see, tomorrow's Thursday? All right, so we're gonna tell the jury that we're done for the rest of the day? Defense have any comment about any of this?
Dr. Clark and James Bible tomorrow, or just Dr. Clark?
Both.
Have them available at least. Great. So at least be available to talk to both of them. Great. So we may have saved ourselves multiple witnesses. Let's hope so. All right, let's have the jury back and then we'll let them know that we're recessing for the day.